This judicial scrutiny doctrine is a creation of the Supreme Court as a way of indicating to lower courts how hard a government must work in order to be allowed to violate your rights. The lowest level of scrutiny is rational basis test, which is a judicial standard of review that examines whether a legislation had a reasonable and not an arbitrary basis for enacting a particular statute. Basically, when the court uses the rational basis test, they're just looking for a good reason for the law, rule, or regulation to exist. Next comes intermediate scrutiny, which is, in order to overcome the intermediate scrutiny test, it must be shown that the law or policy being challenged furthers an important government interest by means that are substantially related to that interest. In order to survive intermediate scrutiny, the court requires not only that the law or policy be reasonable, but that it furthers an important government interest. Lastly, we have strict scrutiny, a standard of judicial review for a challenged policy in which the court presumes a policy to be invalid unless the government can demonstrate a compelling interest to justify the policy. Under strict scrutiny, the government must show not only their interest is important, but compelling. What these court-created definitions seem to miss is the primary interest of government. From the Declaration of Independence, we read that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Government's first and primary interest is in securing the rights of the people, not working out ways government will be allowed to infringe on those rights. This is where the district court's claim about quasi-suspect class comes in. A suspect class is a presumably unconstitutional distinction made between individuals on the basis of race, national origin, alienage, or religious affiliation in a statute, ordinance, regulation, or policy. Now, when the Free Legal Dictionary uses the phrase presumptively unconstitutional, it's rather ironic. You see, the dictionary is claiming that when a distinction is made based on race, religion, etc., it's presumptively unconstitutional. The irony comes in when we realize that putting people in classes for the purpose of special protection under the law is presumptively unconstitutional. It truly is a violation of the concept of equal protection under the law.